All right, good morning, good morning, good morning. It is May 2nd. Everyone is aware that our sessions are public, even though our groups are private. Anything you say is going to be put out on a variety of forums. Be aware of that. Today, we're joined by Greg Weedon. Every one of us knows Greg Weedon. For the odd person who doesn't, understand that there is a marked difference between those people who talk the talk, that's me, and walk the walk, that's Greg. The difference is that it's all well and good that I have some fancy letterhead and other lawyers and myself can throw them around and tell you what the law is. But of course, the law means nothing unless you have a judge that actually agrees with you. And Greg is one of those lawyers on our channel. I see Shanika's here as well, and others who are critical in actually ensuring that the law is upheld by the judicial system. He's the person that so many of us turn to when we have issues. He's also, if I may, and I hope it doesn't embarrass him too much, he has this past year taken a specific lead on a legislative reform which is going to benefit us all, which is the abolition of NOSIs, which I believe he's going to speak about as well. Greg is someone who I call almost on the daily for advice and to make sure that I'm on point. I know a lot of us do. We're incredibly grateful for his time, for his presence. And with that said, I am going to turn it over to Greg. Greg, hit it.
Perfect. Thank you very much. And just for the record, I call Mark on an everyday basis as well to ask for advice. So it goes both ways. And I see some friendly faces here as well. I also call Ty Davis, who's here, who's instrumental in planning act advice. So I'm throwing a kudos out to you, Ty, as well, if you're listening. The advice you provide is greatly appreciated. Okay, so for those who don't know me, I'm a real estate litigation lawyer. I run a small shop in Toronto, and our team really focuses on real estate litigation. Anything real estate based litigation. We have two segments of the business, one just conveyancing, so just regular transactions, commercial or residential, and then I jump in if there's a situation where the deal is on the rails and needs to be resolved, or there's a title defect, or there's a breach scenario, mortgage enforcement, but anything to do with getting the transaction back online or preserving the client's rights to litigate if litigation becomes a necessity. So that's kind of what we do. We've repackaged our business to do a full stop shop for anything real estate and contentious matters for sure. So that's just a bit about me and what we do. And for most part, most of you probably already have had conversations with me about clients, so my line's always open with respect to anything that you guys have a problem with, or any deal that's going sour. Just give me a call or shoot our team an email, and we'll be happy to help you guys out and help your clients out for that matter. But in turn, you guys get paid, and the clients are happy. So that's kind of where we're focusing on getting these deals back online and salvaging them. And if that's not possible, then litigating. So that's just a bit about me. But today I don't have a fulsome presentation planned, but I do want to talk about a few topics that are still hot, and some of them have been hot since 2022, and the market took a dip, so to say. But one of those topics being failed deposits and recent case law on liquidated damages, which I'll explain in a second. And then obviously there's a growing concern for builder bankruptcies as well. I want to talk about a situation with my clients that are experiencing that they're assignees in a transaction where the builder has gone bankrupt. So I want to talk a bit about that as well. The rise in power of sale proceedings. Don't really want to spend too much time on it, but some general advice on what to look out for, and how to save a bunch of time and money with respect to a sale that or a transaction where there's a lender chomping at the bits to close a deal, or a seller that's in a tight spot that can't afford to close the transaction for that matter. So we'll talk a bit about that as well. New construction, build, adjustments, which you guys all know about. Final adjustments at the end of the day, some of them being egregious and unlawful. So I'll take you through a brief example of a case that we worked on last year where the adjustments were outrageous to the point where it increased 10%, and the judge wasn't very happy about that. So I'll give you that example. And then lastly, about notices of security interests, which we refer to as NOSIs, just a bit of an update on that and how it's going to impact you going forward. So it'll be about 30, 40 minutes, and then we can open it up to questions, not necessarily specific questions about your situation that you're dealing with, but more general if we can, because we can't really give any legal advice here for obvious reasons, but we can speak generally for that matter. And if there is a situation where you want to speak to me about specifics, you can just give me a call after or shoot me an email. We can schedule a time to connect. Okay, so failed deposits. So I don't want to go down this path too much, but because I know that it's been beat into everybody's soul here by Sandra Jackson and the other lawyers and other lawyers on the forums. Failing to deliver a deposit is a material or fundamental breach of a contract. Oftentimes, at least historically, buyers or agents or parties in general, have come up with the reasoning or opinion that if you don't put a deposit down, then there's no deal. Well, that's just not the case. So there's no short time to keep reiterating that if you fail to deliver a deposit, you are in breach, and your client is in breach, the buyer is in breach, and there's consequences. So what are those consequences? At the end of the day, if they fail to deliver the deposit and they get sued, and the seller has to sell their property at a loss, and the buyer is going to be responsible for the damages associated with that loss. Now, what happens if a situation where the seller resells the property for a profit? Okay, well, at the end of the day, historically in Ontario, mind you, there is one case that Mark has found, it's brought my attention to recently, but in Ontario, it hasn't been litigated, at least I haven't seen it yet, but where the seller is able to sue the buyer in liquidated damages for failing to deliver the deposit. So there's an example of a case that came out late, I believe it was late last year. It was decided. I'm just going to share my screen. So Sarina Josie, Sulaf Al-Kalari. It was heard in May of last year, and decision was rendered sometime in October late last year. And in this case, and it's a great example of a case where liquidated damages are a live issue, is that a seller sold the property to a buyer. The buyer didn't deliver the deposit. The next day, the day that they were supposed to deliver the deposit, the buyer's agent, communicated that the buyer had no intention to close the deal anymore and wasn't going to deliver the deposit. So, we lawyers would call that, anticipatory breach of contract, but not really relevant to go about here, because at the end of the day, failing to deliver the deposit within 24 hours is a fundamental breach of contract. The sellers terminated the deal, and they reserve their rights to sue for damages, et cetera, after. So in this case, they resold the property, I think about a week later, and they only lost, I think it was $12,000 and change on the resale, and the deposit was $40,000. Okay, so what they did was they sued the original buyers for the $40,000 that they didn't actually deliver. And they sued them under the concept of liquidated damages. Okay, so the concept really is that deposits serve as security for performance of contract. They serve as an incentive to complete the transaction and complete the purchase. And they also serve, as compensation for vendors for losing an opportunity. In this case, they lost the opportunity of selling at the original price, and the consideration that was supposed to be paid of $40,000, was essentially, found to be the liquidated damages amount that the judge awarded. So in this case, even if a seller, well, not in this case, even if a seller makes money on the resale, they sell it for $100,000 more. They don't necessarily have damages in the normal sense, but they have a right to go after the failed deposit amount as liquidated damages. So it's important now to, this line of case law, is very recent. Like this, I haven't seen that, but I've been waiting for it to happen, and this is a really good example of it. So it's going to be used, a lot. I'm telling you right now. We're already using it in cases before us right now, where there's a situation where the buyer is speculating and puts an offer on a number of different properties, and has an agreement signed, and the seller doesn't actually have any damages on the resale, but they're suing them for the 100,000 or 200,000 deposit that we're not paid. So this is a great example of a case where we could use that as a pretty much a sure win situation for a seller that's in this situation. So moral of the story is make sure your clients are aware of the consequences of putting an offer in, and and the consequences that can flow from failing to deliver a deposit, even if there's no damages. So we'll still come after you, but make sure that your clients know that. um, Especially these days, the market's uncertain. Buyers are still defaulting. People, like, parties are still speculating. Like, we're just as busy as we were in 2022 with the decline in the market back then. So it's still a live issue today, with buyers not coming through with their deposits for whatever reason. And the excuses tend to be, they blame the agents. Agents didn't tell us, what the consequences were. So it becomes a real issue for agents and your liability insurers to to defend these cases as well. So um, just make sure that your clients know about it, and you advise them accordingly, and you probably get that done in writing somehow. But yeah, just keep an eye on it, because it's still a live issue. Okay, we can move on to bankruptcies and builders. You've probably seen in the news, there's a few examples of cases or builders. State View Homes is a big one. Van Dyke Projects, another very big one. Even Young and Bloor, that project went into insolvency and receivership. So what's happening in a lot of these cases is, well, first of all, the bankruptcy court has jurisdiction to do pretty much whatever they want in terms of helping the creditors deal with the unpaid debt, and generally that will come in advance, in priority, in advance to the purchasers who have deposits paid. So in the cases that we've been working on, namely State View Homes, for reasons that I'm not going to get into, State View Homes really dropped the ball on this one. There's allegations of fraud and so on. But the moral of the story for that one is that there was no money left over, and the deposits were all eaten up in construction costs, and the buyers had to look to Tarion to do deposit claims under deposit protection. So now Tarion probably paid on State View Homes probably a record amount of claims, probably more so than they were intending on doing. But the where that comes into play, in which the files that we have, a number of files that where an assignee purchased the contract from an assignor, and the assignee purchased it several years ago, and they paid a profit. So they paid 200 grand, let's say, profit. They paid the $100,000 deposit as an example, and they closed the assignment transaction. So the problem is that fast forward 3-4 years, now the builder goes bankrupt. In my client situation, the builder went bankrupt the day before they were taking ownership of the property. So they already did their PDI, they felt the property, they almost had the keys. We were closing the deals, and the builder the next day, like the day before they closed, sorry, the house is no longer yours, no longer earmarked for you, and it's tied up in bankruptcy court for the foreseeable future. So obviously frustrating, and for these purchasers, these assignees, they didn't know really what to do, and where it was going to go. In the court, in that case specifically, they ordered the termination of all the agreements, and they sold the project to a different builder, and that builder made requests for, if you wanted to keep your contracts for the properties, you had to pay an additional, I think it was 120 or 150 grand per contract. So now these assignees were saying, well, I don't have 150 grand to add on to the purchase price. So in most cases, all like those contracts were terminated. And unfortunately for them, the contracts were terminated, and the deposits were also pretty much lost, extinguished, because the rights in the deposits were extinguished by court order in bankruptcy. So if they didn't have carry-on protection, which in this case they did, but the deposits were only 100 grand, so they had deposit protection up to 100 grand. So Tarion ended up paying them out for the deposits, but they've still lost on the profits that they paid, which in my client's case, I think it was 200 or 250 grand, and there's a few files, so I'm mixing them up, but a substantial amount of money was paid for profits on the closing of the assignment transaction. So, naturally speaking, what do we do from there? Like, what recourse does the assignee have to go after the assignor? And it all depends on the contract of what the assignment contract looks like. And that's kind of where I want to, talk about, how it's relevant for realtors or for lawyers to, make sure that they provide protections to their assignee clients on an assignment transaction. So they're not faced with, the uncertainty of what to do next, and they have a clear path forward for this type of situation, which, it's not very novel kind of situation, but it's not new, but, it has been around for a while. Builders are going bankrupt, but we are seeing an influx of them, and we will continue to see it over the next few years. I can tell you that. So just keep that in mind, that we need to kind of change the way we think about how to represent clients on an assignment transaction. One of those ways that we can provide those protections is that the assignment transaction should not complete, like it should not close when the builder provides the consent. So naturally speaking, or conventionally, we would see that that when the builder provides the consent and the parties exchange their funds, the realtors will get paid. There will be a provision that is written into the contract that says, that this assignment will close on this date, or this on triggering on this time period, or this event. I would refrain from using that language at all, and I would try to say that that the assignment transaction closes when the builder delivers the property to the assignee. And that doesn't really change the metrics of anything really. You can still have a provision in there that the agents get paid on certain trigger points, and that that the assignee is going to be the de facto purchaser when the builder provides the consent. But we don't really want the deal to close and the contract to be over until the actual property is delivered at the end of the day. And that just is the main reason behind that, is because the assignors, if that language is not in there, Or if language is in the assignment agreement that says that this deal is closed when the builder provides the consent, then the assignee is gonna look to the assignor and say, okay, I want my money back. And the assignor is gonna say, well, the deal is closed. The deal is dead. Like, there's nothing, we closed this chapter a long time ago. So by opening that door to have, give the recourse to the assignee to, claw that money back, when the deal actually closes with the builder, will go a long way for a lot of people, and for yourself and your insurance providers. So there's really little risk there, and it shouldn't really be an issue for the assignee or the assignor at the end of the day. It just provides protection that is reasonable for a lot of different reasons. So that's one way of protecting your clients there. Also, you can even you can lay it out in Schedule A, and you can say, that if the deal is terminated, or if the deal is if the builder does not deliver the property to the assignee, or if the builder goes bankrupt, then the assignment transaction is null and void, and that all money is paid by the assignee to the assignor to be returned within X days. That's an option as well. And then obviously the better option is that no money is paid by the assignee to the assignor until the builder provides occupancy or possession or closes the deal. That's obviously the most secure way of getting your assignee protected here and avoid this situation. But I know that oftentimes the parties want their money exchanged, and the realtors want to get paid on the transaction. So, quite often that's not the case, and the transaction the money will be exchanged, on the consent of the builder. So keep that in mind, that these are live issues for assignees and for realtors, that and lawyers, that we need to be aware about, that builders are going bankrupt, and we need to protect the clients that are paying for these contracts that are useless at the end of the day. And we need recourse to go back after the assignors for the monies that were paid, and claw those monies back. So that's all I really have to say about that. But just for educational purposes, it is something that's a live issue these days for a number of our clients, and it's working its way through the courts right now as well. And we should have some judgments on it pretty soon, in a few months. So I'll be happy to share that as well with the group when we get there. In terms of power of sale proceedings, it's no secret that people are hurting. A lot of people are in power of sale positions, or defaulting on their mortgages and forced to sell their homes. There's not many statistics on it, but the lawyers in the group can attest to that there are an influx of power of sale files coming in, and situations where people are forced to sell. So quite often you'll have a situation where a seller knows that power of sale is imminent, and that they're forced to sell, and they want to sell before the bank takes possession, or before the bank sells it, generally at a loss. So they try to get as much equity out of the property as possible, and they try to jumpstart the process. But the problem that we're finding is that these deals are coming across our desks, and at the 11th hour, like on the requisition or title search date, we find out that that the seller is delinquent in their mortgage payments, and that the mortgage arrears, or one or two mortgages or more, like the amount that's owing on these, it will actually surpass the sale price. Mortgages. So there are certain ways to to close these types of deals, but it does involve cooperation. And generally what's going to happen is they're going to look to the realtors to cut their commission to close the deal. or the lenders to cut or get a haircut on, on their principal or their interest or their penalties owing. Um, and, quite often, well, it depends on how much, what the delta is, or what the discrepancy is, and how much is owing on the debt. But quite often the amount is doable in terms of everybody working together and taking the necessary haircuts and seeing the bigger picture and closing these transactions. But at the same time, we've had a number of these files fail very recently, where we aren't getting cooperation from the lawyers or the banks or the lenders or private lenders, and the deals don't go through, and the buyers are don't find out about this until the 11th hour, and they come to us, and there's not much that we can do about it, other than try to negotiate some sort of resolution and everybody taking haircuts. But again, there's not much we can do. So we can do to get ahead of it, from before it comes to the lawyers, the realtors should ask the pertinent questions, and pull title searches for on their properties. If they're selling, pull a title for their seller client, before they list it. And if they're buying, pull title of the property that you're about to put an offer on. And just and ask the questions of why are they selling? Are they selling to because they can't afford the property anymore? Well, that puts a bit of a trigger point, a red flag that, well, okay, is it because they're behind in their mortgage? How much is on title in terms of their mortgage amount? Ask the questions about why they're in the situation that they're in, and if they are in a situation where they have debt that's exceeding the sale price or the potential sale price, then might not be a transaction you want to get involved in and waste your time and your client's time on, until you have the certain reassurances that you're comfortable with and proceeding down that type of transaction. But that's really all I want to say about that. But it's a tricky situation, and it's getting worse. I can tell you that the debt, the amount of debt enforcement claims that we're seeing is just astronomical right now. So, and it's getting worse. So it's going to become a more pressing issue, which is going to require more due diligence on your end to appease your clients and make sure that you're not wasting time and not getting paid. So that's all I have to say about that. In terms of new construction deals, with final adjustments or on the statement of adjustments, we've always seen statement of adjustments from a new build, whether it's a condo or freehold property. We've always been we've always dealt with the nuisance, I'd call it, adjustments, the increase in levies and tax levies, water meter installations, and the the $2,000 to $5,000 adjustments, whether or not there's 5 or 10 of them on the statement of adjustments at the end of the day for a buyer. Those are kind of what I would call the nuisance adjustments that
Greg, sorry to interrupt. You're still sharing your screen with the Al Kawari. Can you mind just turning it off for the purposes of a good recording? Sorry about this.
Yeah, that's fine. That's fine. I'm going to flip over to this one then.
Sure, thank you.
Yeah. So in terms of, so let's just rewind a bit. So statement of adjustments, in term what an adjustment is in a new build contract. There will be a series of adjustments built into the contract and also into the carry-on schedule, which provide for in effect increases in the purchase price at the end of the day, based on adjustments for taxes, adjustments for levies, just nominal adjustments for discharging mortgages, etc. But there'll be a series of adjustments that are that benefit the builder that will be those costs will be put on and adjusted, increasing the purchase price at the end of the day for the buyer. So it's always a necessary. My apologies. So it's always that's one of the main things that a lawyer is retained to do, is to review those statement of adjustments from the outset, and to try to negotiate those adjustments, not the statement adjustments, to review the series of adjustments in the contract, and to negotiate those out or down and cap those as best as we can. That's critical for a lawyer or an agent, at the very least, to flag with a client before they get into these contracts. And the consequences of not doing that can be extreme. So one case that we worked on, which I have in front of the screen right now, the Dollywall and Midland Homes, 2023. This case was a case where it was an egregious adjustment, and in this case, the builder, they tried to interpret a paragraph in their contract, which is common in all these contracts, to begin, in my opinion, that if there's a change in the Ontario Building Code or a regulation, then, and if that change in the code or regulation, impacts like construction materials or other impacts, other issues in terms of cost allocation or whatever, then the builder's able to increase or adjust the purchase price accordingly. So, if the government, says, you're no longer able to have, a door on the side of your home, for example, and the builder then needs to change, the schematics or the actual property itself at the end of the day, and the change order there, is put onto the buyer, just as an example. Well, in this case, the builder, Midland, was it Midland Homes? Yeah, Midland Homes. They interpreted that clause to be to allow them the ability to increase the purchase price by $152,000, because they classify that the government's response to COVID-19 and increased, their labor and the materials, and through various different excuses, but they tried to increase. They tried to pretty much put all of their added expenditures from supply chain and so on, onto the consumer, to the purchaser at the 11th hour, and by doing so, they put a $152,000 adjustment on the statement of adjustments, and they try to force a closing within a week or two at the end of the day. Increase the purchase price, I think, over 10 or 15%. So these clients came to me, in a rush, and said, like, we can't afford at the end of the day to close this transaction. We don't have $152,000. And the builder's lawyers were saying, well, if you can't afford to, you're in breach, and we're taking your deposits. So, and this is just one example. This is, I can tell you, there's probably 20 or 30 examples of other cases that we're working on, not so as egregious as this one, but can be interpreted to be as egregious by depending on who you ask. But in this case, the judge didn't agree how they interpreted it, and in this case, they didn't specifically outline this adjustment correctly in the carry-on schedule, and the builder was therefore not able to ask for this adjustment. So we brought this application on an urgent basis before the closing date. The judge eliminated the $152,000 adjustment from the statement of adjustments, awarded my client's costs, I think about 20 grand or 25 grand in costs, and reduced the purchase price by the amount of the cost order. So they came out of this one, laughing essentially, and the builder kind of left with their tail between their legs. And it's just a good example of of a case where the big bad builder is not going to be successful. But a lot of the times, these adjustments are nuisances where, it's not worth it to litigate. It's only 5 or 10 or 15 or $20,000, and the builders are getting away with it on mass scale because they know that the buyers are not going to go to court. They're not going to spend 20, 30, 40, 50 grand in litigation, arguing over 10, 15, 20 grand. So, it's still important to get a litigation lawyer involved if you see a case like this, or a case where you don't believe that the adjustments are fair and equitable. And we can do our best to try to negotiate a settlement before going to litigation, and we have been successful with that very recently as well. So just flag it with a lawyer, and not necessarily a real estate lawyer per se. Nothing wrong with real estate lawyers, but I'm just saying that, like, a lot of real estate lawyers, like, they just miss it, or they advise that you should go to a litigation lawyer. So I would make sure that you get this in the hands of a lawyer that knows this area of the law very well. I can see the lawyers that are on here today are great examples of lawyers that you should trust in that respect, and the lawyers that contribute to the forum here, because they can adequately deal with these, and assess the transaction, assess what the agreement says, and give you the advice. You don't necessarily need to go to a litigation lawyer per se, but oftentimes it just gets overlooked, and I've had hundreds of examples where lawyers they just close the deal and they say, you've signed the agreement, that was what it says in the agreement, and it is, and you can go after the builder after the fact. Well, in this case, it isn't what was said in the agreement, and that lawyer should have understood that he had his limitations, and he should have referred them to a lawyer that knew what they were doing. And that's just one example of a case where just make sure you get these disputes, or these situations into the hands of a competent lawyer that can actually negotiate and do something about it, or lend assistance, and coordinate with other lawyers that are able to press it into court, and actually advocate for your clients in so many ways. So just one example of something just to flag, make sure that your clients are aware of the adjustments, what the impact is, and that a lawyer is it reviews it. A transactional lawyer is all you need to review these contracts and give the advice, and that's all you have to do in terms of protecting your client's interest and protecting a realtor's interest down the line. So that's really all I have to say about that. But there's still live issues. It still comes across my desk all the time about egregious adjustments. So just keep an eye on it. Is all I have to say, and protect your clients accordingly. Okay, last topic. I'll stop sharing my screen. Our notices of security interest. We call them NOSIs for short. You've probably been seeing a lot about it. Mark was discussing it briefly earlier as well. They are beyond a nuisance these days. They started off, essentially what it is it's a lien on title, so to say, securing, generally securing HVAC equipment, or water heaters, etc. Securing consumer goods, or securing loans that were provided to the consumers to purchase and install these goods. Oftentimes, majority of times, the consumer doesn't know that a notice of security interest is registered on title until they sell the property, and generally until they're in their title search phase, which is a week or two before closing. Or they go to refinance the property, and the bank says, we're not going to refinance your deal unless you deal with this NOSI that's on title. And so what essentially has been happening was that that these NOSIs were being used to leverage and extort consumers or homeowners into paying a long-term contract, like breaking a long-term contract of 20 years at 20% interest, with all these fees and penalties on, let's say, a $5,000 furnace. They'd end up spending 20 or 30 grand on a furnace to buy it out, because the contract that they apparently signed, is for a period of 10 or 15 years, and it's at 20% interest, and there's all these default penalties, et cetera. So they're left with a situation where they can't complete a deal, they can't close their deal without paying out, the $20,000 bill on a piece of equipment that's worth, $5,000 or less. So that's always been an issue, and the way to resolve that generally was, that there would be an assumption, of that chattel or the fixture in the agreement of purchase and sale. And so if you knew that there was a water heater there, you might not know that there was a registration on title, but if you know that there's a water heater or a furnace that's rented, then you would put that as, a list of exclusions in the contract, and the buyer would be assuming the contract, accordingly. So you wouldn't have to deal with it per se. A seller wouldn't have to deal with it per se on a closing. Now, the problem is that it's just been like a door-to-door scheme for some time now. And so people would go door to door and they would sell HVAC equipment, furnaces, water heaters, etc. And they would generally be targeting the elderly, the people without capacity, and it became a real problem. Like, same thing with like energy credits. There was a huge influx like late 2000s where people were going door to door trying to package a 10-year energy contract, and they would say that you're going to save X amount of money on the back end of the contract for your utilities or whatever. Anyways, the government shut that down through the Consumer Protection Act. They shut down that, like, no door-to-door sales for HVAC equipment were allowed. So that put a temporary pause on the issue. And generally speaking, it was still a nuisance at that point, like up until about 2018, still a nuisance. There'd still be, $2,000 or $3,000 NOSIs on title for HVAC related equipment. But what happened was during COVID, or just before COVID, these same door-to-door, I would consider most of them fraudsters, would target the same people. They'd be the same elderly clients we'd put onto a list, and they would go back and they would, befriend them. They would sit down for dinner with them, buy them drinks or whatever, and have them sign additional contracts for not just for HVAC equipment, because they weren't allowed to under the legislation, but for home renovations. So they would sign them up for $40,000 renovation for changing out their toilet. And it would be deep into the contract that that they could register a notice of security interest on title to secure it, but they would be telling these people, you don't have to pay anything. We're renovating under a rebate, an Ontario government rebate. There's no ongoing payments required at all. And so what they would do is they would sign like 3 or 4 contracts. And yeah, the next day they'd come in, they'd take a toilet out, they'd replace a vanity, or put new, flooring down in the bathroom, or replace a fixture in the kitchen, and then they would leave. And within 48 hours, there would be like a series of notices of security interest registered on title. So I'm going to show you an example of what of what that looks like. Because this is a pretty good example of how egregious it can get. Okay, so you'll see like a number of notices here, security interest for one Canada's Choice. Oh, what's going on here? There we go. Canada's Choice Capital is a known bad actor here, but in any event, you'll often see the same companies popping up. Green Retrofit up, like you'll see Crown Crest Capital, you'll see Home Trust as well, but they stopped doing it in 2018. But the more egregious ones that pop up, later on. So in this client's example, an elderly gentleman without capacity is currently in a nursing home. In the matter of like literally one day, they had him sign up for renovations, and they registered 3 NOSIs on title for almost 150 grand. And each of these NOSIs were 10-year contracts at 25% interest. So each of these, this $40,000 to pay it out came out to about 90 grand. And so we just do the math on just on these alone, it was almost 250 grand to pay it out. And then they came back, a year later before we got involved, and they registered, same different company with same owners of the company, came back and registered two more for another $100,000. So in this gentleman's case, he had about $600,000 by the time they were done with him in NOSIs registered on title. They also came back and put a mortgage on title, which I'm not going to get into, but in any event, this is an example of them preying on people, and this is just one of hundreds of examples I can show you, where they have them sign up for these promises that everything's going to be paid for, and you're not going to have to pay anything, don't worry. But then they put the lien on title, and you don't know about it until you go to sell. Well, that's what happened here. He was going to sell the property. He was moving into a nursing home, and they pulled title, and we asked these companies who, like, what is this notice of security interest. Then they provide all these contracts that were allegedly signed, and the client has no idea what it's about. And they demand $500,000 to pay out these NOSIs, otherwise the deal won't go through. So that's one of the more egregious examples, but I can show you over 100 of them, and there's thousands of these examples out there, where it's no longer just a nuisance with the HVAC equipment. Like, they're actually going and they're preying on these people for a $5,000 Nest thermostat, or $10,000 security system, and these people don't have internet or any Wi-Fi to run or operate these pieces of equipment. And it's become so crazy in terms of egregiousness. Like, it's insane. So what we did was, we were lobbying to the government for a while now, for the better part of the last 2 years. At the same time, we've been bringing these cases through court, and dealing with them one by one. But a lot of these parties aren't able to afford litigation. Their homes are already, like, the equity in their homes are already depleted because of these NOSIs. So it was a never-ending battle with a lot of these people. A lot of these people have lost their homes because of it. So we're fighting a battle that we weren't winning it. So we started lobbying to the government, and we teamed up with several detectives, the OPP and Regional Waterloo as well. And we started lobbying to Todd McCarthy, was the Minister of Public Business Delivery Services, who controls private lending, or at least administers and regulates private lending and anything to do with PPSA and securities. So we lobbied to them, and we were making pretty good traction on it. And every time that we would get a case, we would be sending it to them to show how bad it was. And then push come to shove, they listened to us, which was great. And they agreed, as of, I think it was February or March of this year, to completely abolish NOSIs from the books, going back retroactively and going forward, obviously. So they're, which is the first time I've seen a piece of legislation like fix a problem in the past. Generally, just for different reasons, for obvious reasons, retroactive laws are not commercially or reasonable in terms of going back in time and fixing things. But in this case, the government did agree with us that it was such an egregious abuse, and the extortion was real and a live issue for a lot of people, a lot of families in Ontario, where they went back, and well, they are going back. Apparently, the legislation is coming out in a week or two, to completely eradicate NOSIs off the books altogether. So that's going to help this gentleman. Actually, this gentleman, we went to court and we got these removed anyways. But people, this is not just one example. There's tons of them, and so it's going to help all the people that have these whether or not it's the $5,000 water heaters on title, or the the $200,000 NOSIs for home renovations that were never done. It's going to help a lot of these people, and the impact is going to be in the billions of dollars. And it's a huge win at the end of the day for the consumers. And obviously for the politicians as well, which they're obviously going to take credit for. But it's something that we're like, I'm going to personally see the benefits of it immediately, but you guys are also going to see it as well, because you're no longer going to have to be aware of the consequences of what a nosy is and how to deal with it on closing, because it's no longer going to be a problem. So at the end of the day, the impact is going to be insurmountable. It's going to be insane. So we're happy that they listen to us, and that that hopefully the legislation comes out sooner or later and they pass it with unanimous consent, because the impact is going to be astronomical. So that's really all I have to say today. I know I went a bit longer, but I'd like to open it up to Mark and the floor and address a few questions and go from there, and we can wrap it up.
Thanks. Well, I'll bring up an interesting question that someone asked above. I think it was David. I'm not sure. But basically the question was, on your first piece of case law, the one where a deposit wasn't provided, would there be a difference if the deposit wasn't provided, but there were still conditions contained in the agreement? That is to say, it was still a conditional agreement.
Is there a difference? No. It depends. So rewinding. So if it's the deposit's not paid, but there's still a conditional period open for financing or inspection, is that what you're saying?
Correct. Yes.
Yeah. Okay. So at the end of the day, the deposit is one of the first, not condition, but it's the first step in delivering the deposit. Is the first step in the performance obligation for a buyer. So if they don't deliver the deposit within 24 hours, the seller has the right to terminate and hold them in breach at that point in time, on the 25th hour, so to say. So the conditional period doesn't matter at all, because the condition there's no longer a condition to fulfill or waive, because the contract has come to an end. But it's important for a seller to bring it to an end and hold them in breach right away, and and assert those rights before the conditional period expires. Okay, because if the seller has the option of just saying, oh, don't worry, buyer, I'm going, you can deliver the deposit whenever you want, like they have that option, and they can acquiesce, and they can accept the deposit later on. But well, if they do that, and and it's 5 days conditional on financing, and they come, and 5 days come and go, then the conditional period, the condition probably calls for the deal to be null and void if they don't fulfill the condition within the 5 days. So then the argument is going to be, well, there is no deal because it was voided, and the seller didn't act on the breach right away. So that's the long answer to that question. It's a bit tricky. It just means that you have to act quickly and assert your rights as soon as possible. Get a lawyer to involved right away, like right away. Don't if it's like, if there's any delay in the deposit, like if there's a huge red flag, no matter how much you trust the agent that you're dealing with on their side, your clients need to know about it like right away, and they need to get litigation counsel on it right away, for sure.
Very good. Okay, guys, let's take 3 questions from the audience, and then we'll wrap up, because we're at 11 o'clock, or we're approaching 11 o'clock. So anyone wants, please unmute yourself, ask your question, 3 of them, and then we'll let everyone go. Or maybe
Hi,
not.
good morning.
There we go.
Hello.
Yep, go ahead. Someone said hi, good morning. Why don't you start there, and then we'll go to Paul, who has his hand up for the second question.
Okay, good morning. It's Betty Ann. Thank you very much. Great information. I'm currently working with an estate that has nosies on it. We're trying to sell the property quickly for financial reasons. What do we do while we're waiting for this to pass? And how does it affect it if we go ahead and close on the estate?
Okay. So, and I'm assuming, like, what are the nosies? Like, is the buyer assuming the nosies, or not?
No, we haven't actually sold the property.
Okay.
We're actually just listing it, and the lawyer has advised that they're going to be paid out by this estate to close.
So your lawyer? So-
Yes, for the seller.
Yeah, so generally speaking, you're going to want to have a provision in the contract. If the contract is not already signed off yet, there's no contract. It would be best as a listing agent to have a provision in the contract that says the buyer agrees to close the deal subject to the NOSIs remaining on title, and the seller agrees to hold back sufficient funds to obtain a discharge of the NOSI within 6 months or a year after closing.
Okay, thank you.
That will give you enough time for the government to bring up the legislation and for the NOSIs to be discharged, and then you can release the money to your client, like the lawyer would release the money to the client, without having to actually pay the NOSIs down. That's what we've been doing, but your sellers are going to want to go to a lawyer that's comfortable, providing that type of an undertaking and knows what they're doing. So you can talk to me offline if you want about what that type of provision looks like, because I've done it a number of times recently. So just let me know. But I should note that while we're on that topic quickly, that the underlying contract itself with the owner and the NOSI holder, that's not going to get extinguished. It's just the NOSI itself, like the leverage on title, that's what's going to go away. So they could still, bring a lawsuit against the owner for, unpaid debt. First, that's not going to go away, but it has nothing to do with the actual transaction itself.
Thank you. I'll reach out.
Yeah, no worries.
Okay, so we're going to do 2 more questions. We're going to do Paul, then Sanchita, then we're going to wrap up. So Paul, please unmute yourself and go crazy.
Hey, Greg, thanks so much for this. And also, I think congratulations from all of us on that, on the work you did there for the NOSIs. It's awesome. With respect to egregious adjustments, in the second example, or the second case you were talking about, I mean, how do you protect against that, contractually, proactively, especially for the ones that are, $5,000, $10,000, $12,000 that aren't worth litigating against? As say the assignee's agent.
Oh, sorry, on the assignment transaction.
Correct. Yeah.
Okay, so in an assignment transaction, I mean, you can negotiate in there that that the adjustments are going to the adjustments will be capped at a certain amount, and that the assignor will be responsible for anything over and above. That's an option. I mean, in today's market, an assigner will probably take that, but in a hotter market, you might not have that leverage. But that would be a good way to protect your clients from having to pay egregious adjustments at the end of the day, or any adjustment that may or may not be egregious. It's just contractually obligated to pay, right?
Yeah, of course. I guess I was thinking more of the 152,000, which was not an assignment, but yeah, okay.
Yeah, in that case, there's nothing anybody could have done. Because in that case, the builder just decided to interpret a very standard adjustment that no real lawyer, no transactional lawyer reviewing the contract would have flagged, because it was a standard provision in most of these most pre-construction agreements. They just decided to get creative and roll the dice and see how many people would actually pay it or not, and we didn't want to pay it. So
Gotcha. Thank you.
Yeah.
All right, Sanchita, you're up. Last question. Make it a good one.
Thanks, Mark. And hi, Greg. Thank you for the great presentation. And again, congratulations, like David said. So I have 2 questions. One is related to David's question. So similar question, but not in an assignment instance. So when I review pre-construction agreements, I always get these costs capped or deleted or whatever. But as you know, most builders come back with, when they have any new taxes or future levies and stuff like that built into the agreement, they typically refuse to delete them. And I don't know if it's, the clients or the agent or who's pushing them to firm up the deal, but sometimes purchasers do end up firming up those deals. So how do we deal with it if at the time of final closing, we see that their new future levy is $30,000 or something crazy that may not be worth litigating, but it's still a lot of money that maybe the purchaser doesn't have at that time, especially given today's market where appraisals are already super low. They don't have any extra money anyway. So how would we deal with that at the time of final closing, given the fact that they've agreed to it and it was perhaps also flagged during my review to them?
Yeah, I mean, I think you've answered the question. I don't know if you can deal with it. Like, there's no way to deal with it. If they've already agreed to it, then it's not egregious. They've already agreed to it, right? Like, if they, if you flagged it and they've agreed and they've got, went ahead, notwithstanding that, that was a potential, potential cost here that they may not be expecting. Like, there's nothing really anybody's gonna be able to do, and they're obligated to pay it.
Yeah.
But it's it's the creative interpretation of and the language that's being used that really that we lawyers need to actually hone in on and figure out how is like, for example, the increased levy provision, like the builders will be creative with how they cap it. So they'll cap, they'll provide, oh, here's an incentive, we're going to cap the increase, the levies, we're going to cap the levies at $5,000 for this. Okay. So, but they don't increase, they don't cap the second part of the provision where it says
Correct.
the increase in the levies between the time that you buy it and the time that you close it. So,
That's right.
So you'll come out with, okay, well, you thought it was capped, but it wasn't capped because there's still an increase of like $5,000 or $10,000 in levies from between point A and point B. So, that's just a situation. Flag it with the client and say, this is a real problem. And, quite often you can't negotiate those things out. So tell the clients that be prepared to pay an extra up to $20,000, $30,000 on closing, because that's just the reality of the situation you're in. But anything more than that, though, probably comes into the egregious category where you want to, really analyze how they're coming up with these adjustments. But yeah.
Okay.
Thank you. That makes sense.
So guys, I'm going to wrap up here. I just want to say one closing comment, which is this. As you are noticing right here, there is a marked difference between those lawyers who know their stuff and those lawyers who do not. Greg is obviously one of those lawyers who does know his stuff. And we are incredibly grateful for his expertise, for his continued willingness to actually educate us and to help so many of us in our community as we proceed with our deals. Greg, thank you sincerely. Thank you to all the lawyers on this channel who I know play similar roles. This isn't to just highlight Greg, though Greg has been good enough with his time, so we'll specifically call him out today. But everyone who gives their time and their attention to this channel, it's appreciated. The level of expertise is making us all better professionals, and we're all incredibly grateful. A copy of this recording will be placed online within an hour or two.
Thanks, everybody. Take care.
Thank you.